Railroad workers who are injured on the job are offered important safeguards by the Safety Appliance Act. The Safety Appliance Act covers basic components of railroad freight cars such as seal steps, grab irons, and cut levers. If a railroad worker is injured as a result of a defect in one of the covered components, the railroad is responsible for the injuries to the employee. Contributory negligence is not a defense in a case involving a safety appliance violation, so it doesn't make much difference if the employee's actions contributed to cause the injury. The involved car must be in interstate commerce at the time of the injury for the Safety Appliance Act to apply, and that means that cars that are in shops or on shop tracks are usually not covered by the Act. What is defective under the Act is typically determined by the performance of the appliance. If it does not perform as intended, it is deemed to be defective for purposes of the Act. It doesn't make any difference if the component acted properly before or after the injury. The test is the performance at the time of the injury. So it's important that if someone is injured under these circumstances, they get the names of witnesses to the injuries, as well as the results of any inspections done of the car after the injury. Federal regulations typically require that a freight car be inspected before returning it to service after an injury due to a safety appliance violation. However, even if the results don't reveal an obvious defect, an injured worker should not assume that there is no evidence to support a case under the Act. All defects should be reported in writing to protect all employees who subsequently handle the car, and an injured employee and his co-workers should make sure that they document all the circumstances surrounding the case to protect subsequent workers.